Hello, everyone. My name is Mandy Sally. I'm the COO here at the Woodhull Freedom Foundation, and I'm thrilled to welcome you to our Censorship Series program this August. I'm very excited because I have a special guest moderator, our fearless leader, President and CEO of Woodhull Freedom Foundation, Ricky Levy. She will be joined by Bob Corn-Revere and Larry Walters, two of our favorite people and two of the most brilliant First Amendment attorneys out there. So we have a very exciting panel for you today. Before we get started, a couple housekeeping things. Please feel free to utilize the Zoom chat if you have questions, comments, reactions. I'll be moderating that during our discussion today, so please make good use of it. Also, this program will be available on our YouTube page afterwards, so no worries if you need to leave early or you missed something one of our fabulous presenters said. It will be available on YouTube forever, free of cost. So thanks so much for joining us today, and without further ado, I give you Ricky Levy.
Hello, I'm Ricky Levy, and I'm the President and CEO of the Woodhull Freedom Foundation. I'm happy to be here this afternoon with two of my very favorite people, Bob Corn-Revere, who is the Chief Counsel at the Foundation for Individual Rights and Expression, and Larry Walters from the Walters Law Group. Both of these amazing First Amendment attorneys happen to also be Woodhull's attorneys in our most recent federal lawsuit, the challenge to FOSTA. We're going to talk about a lot of things today, but I want to start with a little bit about that constitutional challenge. We filed a challenge 5 years ago to the Fighting Online Sex Trafficking Act, a misnamed because it fought no trafficking, a piece of legislation that did and promises to do an enormous amount of harm for marginalized communities, for sex workers, and most importantly, in the basis for our suit, violated our First Amendment. I'm going to ask you, Bob, to begin by talking a little bit about the suit and the outcome and how we won by losing.
I like the way you put that, Ricky. First of all, just by way of background, as Ricky mentioned, we did file this lawsuit 5 years ago in 2018, right after FOSTA had been passed on behalf of Woodhull as the lead plaintiff and 4 other plaintiffs, both organizational plaintiffs and individuals. And the reason for filing it were pretty obvious. Lawmakers had announced a very broad agenda to crack down on anything that they perceived as related to prostitution or sex trafficking, but they weren't too careful about the language that they used. They used very expansive language, and they seemingly authorized a massive crackdown on a wide range of speech that is fully protected constitutionally. We immediately filed a challenge to that because there had been an immediate reaction across the internet of speech being chilled, individuals being kicked off the internet, larger services cutting way back on what they would permit on their platforms. Craigslist, for example, eliminating all ads for personal services, whether or not they had anything to do with sex or sex work. And so the impact of FOSTA across the internet was immediately expansive. We filed to have that enjoined, and then we began what sometimes will happen in litigation, sort of a tortuous path toward trying to get legal redress. At first, the case was thrown out because the district court judge said that we lacked standing, which meant that he was claiming that the law would not have an impact, notwithstanding the fact there had already been a broad chilling effect across the internet. We appealed that decision to the United States Court of Appeals for the District of Columbia, and his decision was reversed. And so we had to go back to the same district judge and argue that the terms of FOSTA were too expansive, the basis on which his original ruling had been reversed. He again essentially reaffirmed his earlier ruling, saying that he thought that the terms of the act were narrow, which took us back to the DC Circuit, where we briefed our arguments and then had oral argument before the court this past January. At the time, we were really encouraged because the panel seemed to be very skeptical of the government's position. But it's one of those situations where, as Ricky will attest, both Larry and I regularly advise clients, you can't predict the outcome of a case based on oral argument for a variety of reasons. One of them is that you're not exactly sure why judges may be asking questions, but also other things can happen. And in this case, the Supreme Court had issued a decision just about a week or two before the opinion came down in the Woodhull case that basically changed the legal landscape and said that a law could be interpreted more narrowly, notwithstanding the fact that Congress had used rather expansive language in how they defined what speech is prohibited. As a consequence, we did receive a decision not affirming our challenges, but upholding the constitutionality of FOSTA. But as Ricky foreshadowed in the premise to her question, it wasn't all bad news, or as some might put it, we won by losing. Essentially, what the court explained, and I think in a measured opinion, that you can't, in this case, apply what you call the plain language of the statute, because doing so would create, as the court put it, grave constitutional questions. And so instead, the court interpreted FOSTA in a way designed to very strictly limit what kind of speech can be prosecuted. So, for example, it said that speech arguing for the legalization of prostitution or that discusses, educates, or informs about prostitution could not be the subject of a prosecution or civil action under FOSTA. It went on to say that it doesn't reach speech engaging in general advocacy or informing sex workers about their rights or in trying to keep them safe from abuse. And that it really is focused on the more specific proof by the government of aiding and abetting involving a particular instance of prostitution. It also limited the terms of some of the civil provisions relating to what amounts to facilitation of participating in a venture involving sex trafficking. So in very key ways, and combined with other recent Supreme Court decisions, the result of the opinion achieved many of the objectives that we set out to do when we filed the case in the beginning, and that is to make sure that the law would not be applied as broadly as Congress wrote the legislation.
So Larry, where does that leave us? FOSTA remains. It's been narrowed by the court, if that's the right way to frame that. Can everybody relax now?
I don't think you can ever relax when you have Congress making laws that impact and potentially infringe on the First Amendment. But we can certainly breathe a sigh of relief to the extent that advocacy groups, harm reduction groups, and others that are engaged in speech related to prostitution were concerned about being prosecuted, Woodhull included. As many will remember, one of the reasons we brought the suit was because Woodhull itself had experienced problems with determining how broad the law would be interpreted with respect to its own summit and its own website operations and discussions of decriminalization, harm reduction for sex workers, et cetera. And the court has now made it clear that despite the fact that Congress used very sloppy and broad language prohibiting any facilitation or promotion of prostitution, that's not how the law must be read. The law must be read as requiring aiding and abetting criminal activity, which has been prohibited for a long time. And if the Congress had used those words in the law, we'd be in a very different situation. But because Congress passed a law that prohibited this broad restriction on any prostitution adjacent speech, that led to confusion and concern about how broad the law would be interpreted. It resulted in many sites being either kicked off the internet or shut down voluntarily, users being accounts being terminated, and a complete disruption of the internet ecosystem because of the, I think, intentionally broad language that Congress used. And so essentially what this decision did was to rein in Congress and rein in the scope of this law to only prohibit what has historically been considered to be criminal activity of aiding and abetting otherwise illegal activity. And that will be helpful in defending lawsuits or criminal enforcement of the FOSTA provisions. It will be helpful in determining how broadly the law applies in website operators making decisions on the kind of content that will be allowed on platforms, or hosts making those decisions. We're in an environment where anything related to sex work was potentially caught up in the bounds of this law. And as Bob said, shortly before the decision came out, the Supreme Court essentially changed the statutory interpretation rules by saying that, well, if Congress uses these broad words, we really have to reinterpret them or look at them in the traditional criminal law context of aiding and abetting, not what Congress actually used in the statute, which is, is very problematic, I would say, in a number of ways, because when people look at these laws, they see the words that Congress used. And historically, you would look at the plain language of the law in determining how broad the law is, how it should be interpreted. But now we are operating under a different set of rules. And according to the Hansen case, which came down a couple weeks before the Woodhull case, when Congress does use these broad, expansive terms, they need to be interpreted in the traditional criminal law context. So, I agree it is a win by losing in that perspective, in that we now have some guidelines how to interpret the law, and the Department of Justice now has been told you cannot interpret this law so as to criminalize speech. It can only be applied to historically criminal activity.
So there's a clause in FOSTA that says if something, I forget the legal term, but fortunately I'm with two lawyers, that if something happened in the past and wasn't illegal in the past, what is that clause, Bob?
That was a provision at the end of FOSTA that applied to the provisions that amended Section 230, which is the legal shield for platforms that carry third-party speech. It made, or at least eliminated, some of the protections of Section 230 for speech related to sex works. It allowed state criminal prosecutions where previously they had been blocked under the terms of Section 230, and allowed certain civil actions as well. But it also had a provision that said this applies whether or not the actions that are being prosecuted or sued took place before FOSTA was enacted. That is a classic definition of an ex post facto law. The court essentially declined to reach the issue because those provisions applied to civil litigants and state prosecutors and not to the federal government. And because only the federal government was a party on the other side, the court determined that it didn't have jurisdiction to issue a ruling as to that provision. At least with that matter of the ex post facto law, the Justice Department had acknowledged that there were significant ex post facto clause problems, because that's one of basic constitutional provisions that you can't make something illegal after the fact. And to his credit, the district court judge acknowledged that wisely the federal government had not tried to defend it on those terms, but instead it was just the technical issue of which parties were involved in this challenge that determined the result that we got here.
But it's still on the books as a law, correct?
It is. The only thing I would add to that is the relevance of the ex post facto provision that you and Bob were discussing is becoming more and more irrelevant or non-consequential over the passage of time, because now we're in 2023 and we're not aware of any actions, any lawsuits or enforcement actions that had been undertaken by the government or state attorney generals for activities that occurred prior to the law passing. And the statutes of limitations are expiring on most of these criminal activities now that we're in 2023. I mean, 5 years is a typical statute of limitations for a federal criminal offense. So, it's highly unlikely at this point that the issue will ever be raised now that, multiple years have passed since FOSTA was enacted with that clearly unconstitutional provision. So, it would have been certainly nice to get a confirmation that the ex post facto prohibition still works and is still in effect. And it clearly is a violation, but there has been no actions brought under that provision that would allow us to raise that issue at this point.
Yeah, but it is another example of this sloppy legislative draftsmanship that essentially the court cleaned up for Congress. One of the problems of having courts do that instead of holding Congress to the language that they used is that it is not good civic hygiene to let Congress, which is itself a constitutional decision maker, off the hook in being careless with writing laws, particularly laws regulating speech. In years past, and depending on which court you're in front of, courts have held Congress to a higher standard. Here, while the sloppy language of FOSTA remains in place, we now have a definitive interpretation saying, don't listen to the language Congress used, listen to the legal concepts that we are imposing on this law.
Oh, doesn't sound very good.
Well, it sounds better than if the court had upheld FOSTA by saying it can be enforced as expansively as the plain language suggested it could.
So one of the things that Woodhull is working on right now, in addition to our focus strictly on the First Amendment, is age verification, which I don't see it as a standalone issue. I feel like we're playing whack-a-mole here, that free speech, that access to information, access to sometimes life-saving information, is just being restricted in any way that people can creatively come up with. So age verification, certainly access to age-appropriate information or content is something that we generally support. But age verification, the way it seems to be developing from the bounty laws in Utah to the laws in Texas that are now under challenge in a lawsuit that was just brought the other day. Where do you two see this going, and what do you think the constitutional issues are? Larry?
Well, that's a great introduction. Age verification with respect to adult materials is a very hot issue now. We have a number of states that have actually enacted these prohibitions, starting with Louisiana, Arkansas, Mississippi, Montana, Texas, Utah, and Virginia have all jumped on board. And this issue really is one that had been settled already through a series of cases, starting with the challenge to the Communications Decency Act in 1997, when the Supreme Court struck that down as a violation of the First Amendment, to the Child Online Protection Act, which was also struck down by the federal courts, and a series of state court decisions where the state courts attempted to require age verification from users before accessing adult materials online. So, we had thought that that we had seen the end of that issue, but as a result of some creative lawmaking, we're now seeing it rise from the dead. This started with the bounty law in Texas related to abortion, right? So Texas created a law that allowed anybody that had information about a doctor performing an abortion illegally could sue the doctor and get damages. Why lawmakers crafted the law that way, I believe, is to intentionally frustrate the ability to bring a constitutional challenge to the validity of the law. Reason being, as we discussed briefly in the standing decision related to the Woodhull case, the plaintiff suing has to show that they are affected by the law and that the court decision can redress the constitutional violation. Well, here, if you are, let's say, an adult website operator and you want to challenge one of these laws, the question is, who do you sue? The government cannot enforce most of these laws. There are a couple now that the government can enforce, including Louisiana and Texas. But in a lot of them, only private plaintiffs can enforce the law. And so, you can't realistically go and sue everybody in the state of Utah who might enforce the law, or every citizen. So there's not really an obvious defendant to file a lawsuit against. And this, again, is likely intentional, so that the laws kind of just sit there and remain unchallenged and create an environment of uncertainty, which ultimately chills protected speech. Oh, I have an issue with camera. Oh, sorry. That ultimately chills protected speech in a couple of ways. One is website operators are increasingly geo-blocking the territories where these laws have been passed. In other words, not allowing citizens to get access to sexually oriented materials in those states. So the online freedom of those individuals to access the materials and the freedom of the website operators to distribute the materials, which are constitutionally protected, is being chilled by this kind of forced geo-blocking as a result of the age verification laws. Secondarily, the users who don't want to provide IDs that could potentially be hacked and exploited by cyber thieves and so forth are not providing the information, and therefore they're not gaining access to the adult materials that they want to view or read or watch. And so this results in the classic chilling effect on First Amendment rights and a prohibition on dissemination of protected speech. And the advocates of these laws want that. I mean, that is the ultimate goal, is to prohibit adult content on the internet. A lot of the anti-sex, anti-porn groups are behind these laws, and they want to create this environment of uncertainty and difficult ability to challenge the law, so that the chilling effect manifests itself and the content cannot be accessed in those states.
So Bob, from banning books to restricting classroom discussions, speech is often censored. Speech and adult content is often censored in the name of, and this is in air quotes, protecting the children. It's one of the flags that's often flown to get some of these laws passed. Arkansas recently passed the Social Media Safety Act. And that requires every person to verify their age before they can access existing social media or create a new account. If a user can't show they're at least 18 years old, and I'm quoting, using a commercially reasonable age verification method, potentially including biometric screening or requiring government-issued ID, the law requires that they obtain parental consent. So now this isn't bounty hunting. This is a much more global censoring than just you can't access adult content. This is you can't go on social media unless you can prove who you are and how old you are. What do we do with something like that?
Well, that's right. And Ricky, the premise of your question begins with an age-old adage that children are the universal solvent for First Amendment rights. That is, so many restrictions on speech are done in the name of protecting the kids. And that's a tradition that goes back 150 years, back to the 1870s. And you're right, this isn't limited to just the issue of adult websites online. That's one way in which this issue has currently manifested itself, but it's much broader than that. And it goes back even to, movies, adult bookstores, that kind of thing. But it is something that popped up again in the early internet cases in the late 1990s, as Larry had mentioned. Also, as he said, those issues had largely been resolved in First Amendment terms, and that is a federal restriction that was designed after the Communications Decency Act was struck down, was similarly struck down by the courts. And every state that had tried to adopt what were called at the time mini CDAs were struck down as well. And so this is, I'm not surprised to see it. It's sort of the same kind of life cycle of your typical moral panic. But what we're seeing now is that it's expanding, as I said, beyond just adult websites, but to access to any social media sites where you have to have proof of age. This stretches way beyond the boundaries that have been permitted in First Amendment cases in the past. I believe these measures are unconstitutional and they are currently being challenged. California last year adopted what was called the Age Appropriate Design Act, which similarly is designed to protect the kids and is styled as a privacy regulation. And yet all it really does is regulate online content and forces online platforms to, in effect, build their own cages by doing assessments of all their products, services, or features, that is speech, and then determine whether or not that might be harmful to children in some way, and then to adopt measures to mitigate or eliminate whatever that risk is, however you might define it. So it is a broad scale attempt to regulate online speech, not just adult speech. And you can see this kind of moral panic popping up in many different ways. I read a news story just yesterday about one county in Virginia where a county supervisor is proposing requiring proof of age if you're under 18 to go to the public library. Now, this affects constitutional rights in so many different ways. It affects the rights of adults who may not want to have to show their papers to be able to pick up a book. It affects the constitutional rights of minors because the existing law protects minors, or at least it leans toward protecting minors and recognizes that you can only really restrict speech for the younger, more vulnerable segments of the population. And also, ironically, even though these measures in many cases are adopted to protect privacy, it requires people to relinquish their privacy in order to get access to speech, whether it's the adults who are going to be reluctant to show ID in order to access materials, and certainly minors as well. And so there are so many ways in which these proposals represent a negative trend that I think will ultimately be resolved by the courts, and I'm optimistic that they'll be resolved in the right way.
Do you have a timeline for that?
Well, I mean, you've got the Free Speech Coalition that has filed lawsuits on behalf of plaintiffs who are affected by laws in Louisiana and in Texas and in Utah. And so we've got preliminary injunction hearings, motions have been filed. It is possible that these issues will be resolved quicker than the FOSTA case was.
Well, the timeline, I understand, for the Texas lawsuit is really tight because the law is going to go into effect September 1st. When I heard that timeline, I thought, oh my gosh, it took us 5 years.
Well, that's right. And we should be seeing some of those results more quickly than that we certainly saw in the FOSTA case. And as Larry had mentioned earlier, these challenges and the laws that are being challenged are not all the same. In Utah, there was a sort of bounty hunter provision, the sort of vigilante provision that had that case being dismissed based on standing because, again, it was enforced by citizen suits rather than by the government, making it not amenable to a pre-enforcement challenge. But the one in Texas, for example, is enforced by the state, and it imposes labeling requirements on adult sites. So that one is subject to a pre-enforcement challenge. I wouldn't expect to see a dismissal the way there was in Utah in that case, for example. So I think we will be seeing rulings on the merits of the law, or at least preliminary rulings in the injunction hearings that talk about the merits of the law and the constitutional issues that are involved.
So Woodhull is incredibly proud to partner with FIRE, the Foundation for Individual Rights and Expression, and the Free Speech Coalition. And a lot of this advocacy and these legal challenges, in one way or another, we partner with both of those organizations. What could an individual do? How could an individual address the onslaught of legislation coming down the pike, COSA and Earn It, and COSA, which is, I understand, likely to pass unless we're able to continue to mobilize the way we've been. What options are there for individuals? I know this isn't First Amendment law. I'm asking your opinions.
Well, I think the one thing that people should do is just stay informed about these issues. I think being aware of what the incursions on individual rights are is the beginning of any kind of effective advocacy. The other thing that you can do is just support organizations like Woodhull and FIRE and others. Certainly the Free Speech Coalition is fighting the good fight. There are many organizations to choose from that are trying to shoulder the effort and hold the line on constitutional rights.
Yeah, and it largely depends on who the individual is in terms of what they're able to accomplish individually. Supporting groups that have the resources and the ability to impact legislation and court rulings through amicus briefs and lobbying and legislative efforts, that's always important. But so is vocalizing your opinion on these issues, particularly if you have any kind of platform or audience or social media following. You've got a direct line to lawmakers through their social media accounts now. And in one of the states, that one of the lawmakers who was supporting the age verification bill was stunned to see how many people were complaining about this age verification law and responded something like, it's just porn. What's the big deal? Couldn't imagine that there was this backlash that would be mounted against this effort. And so they need to hear from people who are being affected by these laws, and it's a lot of people. If you look at the stats on consumption of adult materials, and there's a lot of people looking at that content, and so their rights, their privacy rights, their First Amendment rights, and the obligations that they're being required to undertake to get access to these sites are being impacted. And so people are starting to speak up, and I would encourage all people listening to this recording and this session to get informed, get active, vocalize how they feel about this issue, and tag your representatives if they're sponsoring these bills.
So, Bob, thank you both. Bob, what do you think the landscape is going to look like in the next 5 years as far as censorship and restrictions on the First Amendment?
Well, in 5 years, we're going to see a lot of rulings on the measures that are being enacted today that will help us better understand whether or not our rights are still protected. By that time, we will see Supreme Court rulings on some of the current kinds of measures. I remain optimistic that those constitutional rules will remain firm. Because I think the Supreme Court in general has been very speech protective. I think that the court recognizes the risks, and there have been rulings even from this term. The court had the opportunity, for example, to undermine Section 230, which was a central tenet of at least a statutory way of upholding First Amendment rights. The court refused the invitations to undermine Section 230. It also adopted more stringent requirements to demonstrate when an online platform might be considered aiding and abetting in a case involving Twitter and terrorist-related sites. And in those decisions, and in another one involving online stalking, the court indicated it was really aware, and a substantial majority of the court indicated it was really aware of the consequences of undermining online speech. And so in 5 years' time, we will see a number of the current controversies working their way up to the Supreme Court, where we will get ultimate clarity on what the state of the law will be. And another of the reasons why I remain optimistic is not just for the current short-term view, but over the longer historic term. We have seen these kinds of censorship efforts come and go. They come in cycles. You see one moral panic after another, whether it's jazz music or comic books or rock and roll or video games. Those controversies ultimately work their way through the courts. The public, in the midst of a moral panic, has a hard time seeing clearly, but looking back on it years later, they wonder what all the fuss was about. And I think we'll see that both in terms of the law and I think in terms of public understandings.
What do you think, Larry?
I'd echo largely what Bob was saying. We've seen these moral panics come and go. It's kind of like a pendulum. We saw the efforts to crack down on adult content in the 70s, 80s, 90s, and for a while things had calmed down a bit, and there were publications suggesting that the war against porn has been lost, and morality in media basically went broke, and things were going smoothly for a while. So we were about due for one of these moral panics, and so it's not surprising. It seems that legislators have a short memory as to what the Constitution requires. I suppose there's always new people coming into these state houses and senates, and so they've got to learn. But it's ultimately, I think the courts will right the ship. And right now we're just kind of going through the growing pains as this new round of legislation and crackdown on human sexuality is manifesting itself.
Yeah, and what this illustrates is that the fight is really never over. No one is ultimately going to end the debate over these issues. as Larry just said, these moral panics come and go like the swinging of a pendulum, and we always have to stand ready. It's like the old line that the price of liberty is eternal vigilance. The price of free speech is always being willing to take the necessary cases to make sure rights are preserved.
This is probably a little tangential. When I began this work, I would have described myself as an absolutist in terms of the First Amendment. Bob, you and I had a conversation once about the not absolutist nature of the First Amendment. It feels very important to me right now that we do everything in our power to preserve the First Amendment. Any speech that's censored becomes government speech. And I don't think anybody wants that, as the government's the only one who can speak when they've censored everything else. What do you think about that?
Well, just to chain off on that, as you and I have discussed, I don't believe that absolutism exists in the First Amendment realm. I've been described as a First Amendment absolutist, but as I say, I don't believe they exist, because it's always possible to commit crimes using words. You walk into a bank and hand the teller a note that says, "Give me all your money." You're robbing a bank. It doesn't matter with the fact that you're using words. And so there are limits. But what we have in this system are very carefully defined exceptions. The idea is that under the First Amendment, we presume that speech is protected. All speech is protected, except for certain limited and well-defined exceptions. And the entire battleground that we find ourselves in is trying to maintain the limits on those exceptions. This whole question of the protection of minors and whether or not restricting their access is to whatever information is a First Amendment problem, is a matter of making sure those exceptions remain limited. So if you'll remember the controversy about video games from 10 and 20 years ago, many states started adopting these restrictions. It ended up going to the Supreme Court. And the whole issue was where the states were trying to say, we're going to take these harm to minors concepts that previously had only been applied to sexual material, and we're going to apply them to video games because we think violence is bad too. The whole issue at the Supreme Court was, are we going to allow the expansion of an exception related to what minors can see to these other concepts instead of just sexual material? And the court, in a wonderful opinion, basically said, no, we're not going to allow these exceptions to be expanded. It's not First Amendment absolutism. It's a First Amendment presumption that speech is protected, and we're here to hold the line.
I like that. Thank you. So, Larry, speech that offends no one needs no defense. You have spent an illustrious career defending the First Amendment around speech that offended someone. Where do you see that going in the future? Do you think, we say if it's about sex or sexual freedom, it's under attack. I think that's probably been eternal. But where do you take this?
Well, it's always the controversial speech that sets the standard for the rest of protected speech. You don't need the First Amendment to show the sound of music. It's when you get to the edges and when you start offending some with your speech, that's when the government starts to get riled up and the public, and that's when the First Amendment is the most important to build out those contours and to establish those boundaries and hold the line, as Bob said. I agree that the current Supreme Court is holding the line. They've been given a couple of opportunities recently to expand these exceptions to the First Amendment for video games or animal cruelty videos and things that offend the public. But the court has over and over again said that these historic exceptions have been there. They're well grounded, they're well established. We're not creating any new ones. So stop trying. And so long as that maintains in the Supreme Court, and the Supreme Court does not become convinced that new exceptions need to be made, that I think we're going to be absolutely fine. But the controversial speech will continue to result in prosecutions and new regulations. It's sexually oriented speech, but it's also speech involving politics or drugs or terrorism or immigration or fortune telling, or you name it. And I've defended it probably, but there's always going to be somebody that's offended by another's speech. But the Supreme Court has maintained over and over that even vile and offensive speech maintains First Amendment protection. And that's where we have to hold the line.
Yeah, as the Supreme Court memorably said, one man's vulgarity is another man's lyric.
Who said that? Do you know?
Justice Harlan.
I like that. I like that. So we're about at the end of our time. I want to give you each an opportunity, if you want it, to make some closing remarks. And then I'm going to thank you effusively. So Bob, why don't you begin?
Well, I'll simply repeat a theme that I've tried to sound in this, and that is we are going through a time of significant challenge right now. There seems to be interest on all sides, both from the left and the right, to adopt a myriad number of restrictions on speech, sometimes in the name of protecting kids, sometimes just because they don't like the speech involved. But as I said before, I remain optimistic because the principles by which we defend the concept of free expression have been upheld by the courts, and the trend for those protections remains strong. And so we go through a time when we suffer setbacks, and we pick ourselves up and we take the next case and try and keep that trend going. And that's what I think is going to happen.
Thank you. Larry?
I'd absolutely agree with Bob's wrap-up thoughts. We saw with FOSTA an effort to try to enforce censorship of disfavored speech by using online intermediaries, hosts, and platforms to do the government's dirty work, to censor speech that they could not directly censor themselves. The same thing with these bounty hunter laws, encouraging citizens to do the dirty work of the government. The same thing with these efforts to communicate with social media platforms and governmental officials asking for disinformation and speech to be taken down. I think that is the one area that we need to watch very carefully, is the government putting pressure on or incentivizing third parties to censor speech, because there's a lot of power that is outside of governmental hands that can have a dramatic impact on speech. And we remain ever vigilant on that issue and all issues impacting freedom of speech and the First Amendment. And it's a pleasure to have represented Woodhull in the FOSTA case with Bob and the entire team, and I appreciate the opportunity to shed some light on the decision and some of the other things that have been happening in the free speech realm.
Thank you. When I start my day and I think, oh my God, there's so much wrong, I can think about the two of you and think, but we're going to be okay.
Well,
I
Rick,
thank you both.
It's been a pleasure.
Thank you so much.
Thank you.
All right. Well, I want to thank Ricky and Bob and Larry for this amazing panel today. I know I always learn a whole lot from them, and I really appreciate them being here, not only to share their knowledge today, but also for just being wonderful supporters of Woodhull for a really long time. We love them and we're happy to have them with us. So, thank you again to all of you for joining us today. If you enjoyed what you learned today or you learned something new, please head on over to woodhullfoundation.org/donate and make a donation. We work really hard to make free, accessible programming for you. And if you learned something, we'd appreciate the donation. So thanks again for being here. All of the links and resources that our panelists talked about today will be included in a wrap-up email that you'll receive from me in the coming days. So don't worry if you missed something. I'll send you a link so you can follow up. And we'll be back next month in September. We're going to be focusing on book bans and why they seem to be so popular in the United States right now. So stay tuned to your inbox and Woodhull's social media for more information about next month's program. And last but certainly not least, I want to thank Kaylee. Kaylee is our wonderful ASL interpreter. She's been with us for many of our programs, and we really appreciate her being here. So thanks again, everybody, and we'll see you in September.